You aware that because of my hand surgery, it was a disability?
Because of your hand surgery that you had disability?
Yes, so because of my hand surgery and the prescribed medications that I was prescribed from a physician, my hand was a disability that I was taking medication for. My,
Okay, if you say so.
okay, so had you ever heard me ask you that I don't have sufficient rides to get back and forth throughout the week?
Yes,
Um, does your facility accommodate people that have disabilities to get back and forth?
we don't offer rides if that's what you're asking.
Okay, I mean, so being a supervisor, um, shouldn't your facility accommodate people to get to the facility?
I don't think that's a relevant question. She's testified that they don't offer rides.
Okay. Back to Mr. Bivens, coming back from Arizona, and you're his supervisor. Do you guys provide people that get referred to your facility with policies and procedures?
No,
Are you required to?
no.
Because through the legislation, you're required to do this. If people,
And with all due respect, sir, you can ask her a question. That's argumentative. You're testifying, so ask another question, sir, if you have one.
okay. Mr. Bivens, he told me that I had to go ahead and fill out the paperwork again when I got back from Arizona. And so being that I asked for the policies and procedures, you guys, is it fair to say that you guys make up things as you go along?
No,
Okay. Are you aware that on all my paperwork that I have, almost every one of them are marked that I was working full time?
the case managers mark, they ask you that question and they mark what you tell them.
No, that's untrue.
Respectfully, sir, don't argue with the witness. You can ask questions.
Okay. So are you aware that on my paperwork, it was saying I was working full time?
On some of those papers, sure.
Okay. Just for, I guess the record, I was not working full.
Sir, with all due respect, you're asking this witness questions. You're not testifying. If you want to testify, Mr. Ortega, you'll have an opportunity to do that. And when that happens, Ms. Pearson can ask you questions. So you can't testify now. This is not your opportunity to testify or present evidence. You're asking this witness questions.
Okay. And so I'll be able to testify today.
If you want to testify, yes, sir.
I will like to do that.
So do you have any other questions you want to ask, Ms. Tuttle?
On a level 3 supervision, you never said anything about having a person take a mobile breath and being on a mobile breath system. Is that not a part? Because I asked you what it consists of. You never mentioned the mobile breath.
You asked me about intensive supervision. So I was explaining to you what intensive supervision was.
Well, according to RMS,
Sir, respectfully, she's answered your question. If you want to ask her another question, you can do that, but don't argue with her.
the level 3 intense supervision, does it require people to have a mobile breath unit given to them and take wherever they go with it?
So the level 3 portion of your bond is what requires you to have the mobile breath unit. The supervision level, your intensive supervision, you could be a level 3. If the court ordered a level 3 supervision, they could have you on a different supervision level. You specifically were ordered to level 3 DUI with intensive supervision. The level 3 is what requires the urinalysis testing and the mobile breath testing.
All right, so that was the end of the first witness. I mean, they both still have a few questions to ask her, but she's going to be called back up to the stand later in this video. At this point, he begins to make his case for why he shouldn't have to abide by any of the pretrial release conditions, and let me tell you something, he has the wildest excuses that you can imagine, and the judge isn't going to be buying the bullshit that he's selling.
Did you have any questions, Ms. Pearson, that you wanted to ask?
Just a couple. Ms. Tuttle, has Mr. Ortega ever been fully compliant with his bond conditions?
With every portion of it? No.
Of the medications that he provided, do you know if you have other clients with those medications?
Probably so.
Does it make it so they can't report to RMS?
No,
Does it make it so they can't provide UAs?
no,
Does it make it so they can't do the mobile breath tests?
no.
Do you have clients that use MedRide,
Some do.
walk,
Yes,
ride a bike?
correct.
I have no further questions.
Did you have any additional questions based on Ms. Pearson's questions, Mr. Ortega?
Yes, I did, Your Honor. Mrs. Toll, were you aware that I was riding my bike to get back and forth to RMS?
Sometimes, yes.
Okay. Knowing that I was on prescribed medication and speaking with some of your supervisors at RMS, they told me that if I didn't show up for my scheduled meeting, they were going to send an affidavit to the judge for my arrest. Is that correct?
They probably informed you that they would send an affidavit for noncompliance because you weren't complying with your bond conditions.
Right. But they also said that they would send an affidavit to the judge for my arrest.
I can't speak on what they said.
Okay. So knowing that I was on prescribed medication and you knew that I was taking my bicycle to get there, I mean, didn't you think that possibly was an issue at any point?
How you get to the office has nothing to do with us. If you're court ordered to be in the office once a week, then if you don't come once a week, then we have to inform the court. That's our job.
Okay. Has there ever been anybody that had a condition that you were aware of that it was hard for them to get to RMS?
Yes,
Okay. And did you accommodate anything for them to be able to get there?
we can't make accommodations. What we would say is you can file a motion with the court and request phone meetings, and then we can do the meetings over the phone. But we can't give you rides or say you don't need to come in because you have this or that.
On some of RMS's paperwork, it says that you guys are counselors, correct?
No,
I have proof of that. I just don't have it with me today, Your Honor. Being said that counselors are,
She's indicated, sir, that they're not counselors.
Oh.
So any question about counselors or what counselors might be required to do or not do, it's not relevant.
okay. I do have a copy here, Your Honor, of.
Sir, and again, what you're doing is asking this witness questions.
Okay,
Do you have any other questions you want to ask her?
yes. Do you remember when I put in the non-consent form on the 25th?
Objection outside the scope of cross.
I'd allowed some testimony regarding this earlier, so I'll go ahead and allow it.
can you ask your question again?
Yes. Are you aware of the form that I gave to you, actually RMS on the 25th of February saying that I did not consent to them taking my urine, doing any more testing on my urine?
I said, I do remember you provide, I don't know what date you provided it, but I do remember that form, yes.
Your Honor, I do have a copy of that. I'd like
And
to.
again, sir, this is not your opportunity to present evidence to the court. You're asking this witness questions.
Okay, no more questions, Your Honor.
Ms. Tuttle, can Ms. Tuttle be released? Ms. Pearson?
Yes,
Mr. Ortega, can Ms. Tuttle be released? Ms. Tuttle, I appreciate your time with us. Just don't discuss your testimony with anybody. Yeah, if you'd like, yeah. I'm going to let Ms. Tuttle, if she wants to stay in the courtroom, she can.
Your Honor,
But she wouldn't be recalled by either side.
May I use the restroom?
Sure, we'll take a short recess. And then let me just ask, Mr. Ortega, and I'll let you take a recess. Are you intending to call any other witnesses?
Well, I would like to call more witnesses on my behalf, but I wasn't prepared for this.
Well, there's two witnesses that are here, so while you're using the restroom break, you can let me know, think about whether or not you want to call any other witnesses
I'd like
and
to
then,
call.
okay,
Thank you.
so we'll be in recess for a few minutes.
At this point, they take a short break so that our living brain donor can go and take a piss break. And when they come back, he tries to call a few witnesses on his own behalf. But since he only wants to reaffirm what the first witness already testified to, the judge denies his request.
Why don't you make an offer of proof to me, Mr. Ortega, why you want to call Miss Miller?
Your Honor, on several occasions, Mrs. Miller, was my case manager. And, there's paperwork that I have, and here's one of them that I did happen to have with me. They're falsified. And so I like to call her, and cross-examine on it to ask her questions.
And the document that you have that you want to ask her questions about, what is that document?
It is a RMS document right here, with her signature on the bottom.
Okay. Can you show that to Ms. Pearson?
Yes.
And can you approach Mr. Ortega so the court can look at the document?
And that's how they copied it for me, Your Honor, just like that.
And is this the only thing that you want to ask Ms. Miller questions about?
No, I'd like to ask her, as far as, what her, level 3 is, intense level 3. I'd like to see what she.
Well, and I'm not going to allow that because Ms. Tuttle's testified about that. So respectfully, sir, what part of this document, and this appears to be a document, did you write on this document?
I did write on that document. I wasn't planning on using it for evidence, but
Okay.
since you said that I could, well, since I called her to the witness stand and her name's on it, I would like to use it.
What specifically are you going to ask her about? What do you believe is false on this document?
It says that I was working full-time on there and I was not working part-time, actually. It says part-time. She marked the box part-time. I was not working part-time.
Okay. So that's the only thing that you're saying is inaccurate on the form.
Well,
Is that correct?
I believe that there is other things that are,
Why don't you tell me what information on this form, Mr. Ortega, you're alleging is incorrect or false? So that's the one thing, the employment. What else?
well, after I put the non-consent of them testing my urine, they continued to test my urine.
Right. And so that's respectfully, sir, just because you say don't give your consent doesn't invalidate any court order that you comply with the conditions of your bond. So that honestly is irrelevant because unless the court modifies that, you don't have the ability to unilaterally say, you can't test my urine. You don't have the right to do that. So that's irrelevant.
Okay, well, I'd like to cross-examine her on, how she assesses different people with different disabilities.
And I don't know that that's necessarily relevant either, Mr. Ortega. Can you tell me why you think that's relevant?
Because I wrecked my mountain bike going to their facility and they knew that's the only way I was able to get there on occasions.
Okay.
And so I went to the ER and let them know that I went to the ER to try to get there to accommodate their facility because of it's a court order.
And so I don't understand the purpose of asking her questions about that.
Well,
That you wrecked your mountain bike going to the office and tell me how you think that impacts them. I'm not understanding you.
Yeah, so it impacted me for the court order to go through them, and I ended up in the ER, and that's irrelevant.
Yes, it's irrelevant. I mean, it might be relevant for why you missed an appointment on the day of your bike crash, but it doesn't excuse the totality of your non-compliance on pretrial release.
It is irrelevant. I mean, if you think it's important because that maybe impacted your ability to comply with a particular condition on a particular date,
Okay.
you know, that might be relevant. But the fact that you were riding your bike and you got in a wreck and you had to go to the ER in and of itself is not relevant.
Well, the only thing I can say is, I guess that's the only thing that I wanted to question her on, because she's done it on different occasions as far as mark the box that is untrue. And there's some of the paperwork that I have saying that I was working full-time. That one particularly says that I'm working part-time, but there is ones that she particularly, and I know this for a fact, and I
But
have,
that's the only thing on the form. Did you ever represent to them, Mr. Ortega, that you were working part-time?
I did.
Okay,
At some point I did, after my hand started to heal.
okay. So then the information in July of this year, were you working or had you been working part-time prior to that?
I don't know.
You don't know when you were working?
Well, the thing is, Your Honor, I was on medication from the beginning. I have the transcript saying,
Okay.
Your Honor, I can't make my own decisions, I don't think,
Okay,
because I was on medication.
so the only concern, I just want to make sure, Mr. Ortega, the only concern that you have with this form that you believe is inaccurate is that the box was checked that you were working part-time and potentially on another form checked that you're working full-time. Is that right?
Well, honestly, she had marked on different occasions that I was on some kind of amphetamine, which is untrue.
Okay, you don't have those forms though with you.
I do, not with me, but
Okay.
I do have them.
Okay. So I really don't think that that is an issue that is necessarily relevant to my determination as to whether or not you violated conditions of your bond. The fact that you've expressed to me today that in fact you were working part-time at some point, I don't know that that box, if it was inadvertent, which the court believes probably realistically was inadvertent, I don't know that the checking of that box really impacts anything from my perspective in terms of your compliance with the conditions of the bond. So
No.
if you don't have any other questions for Ms. Miller other than that, I'm not going to allow, I don't think I need to hear from her
Okay.
as a witness.
I do, I'd like to ask her if she knows what the bill and the bill for the act of concerning pre-trial release.
And she's not in a position to answer any questions regarding that. So her testimony wouldn't be relevant for the court as to that issue either, Mr. Ortega.
Well, I mean, I object to that because they are the
You
pre-trial.
can certainly object to it. And we're on the record here, but I don't think it's relevant to my determination. So other than that, was there any other question you wanted to ask Ms. Miller?
No, Your Honor.
And were there any other witnesses that you wanted to call?
I do have some, but they're not on my behalf that I think they should be here.
If there's a witness that's here today, sir,
John Bivens.
okay,
Sir.
and I'll do the same thing with Mr. Bevins. What do you want to call Mr. Bevins for?
Well, I want to ask him, with their policies and procedures, that they have to have some kind of policies and procedures.
And again, I think Ms. Tuttle's testified. She's the manager. So Mr. Bevins is just a case manager. So I don't think that his testimony, frankly, is going to be relevant or helpful to the court because I've heard from Ms. Tuttle. So was there anything else you wanted to ask Mr. Bevins?
I wanted to ask him about the instance when I came back from Arizona.
And Ms. Tuttle's testified about that, and I don't think I need any additional testimony regarding that. Anything else, sir?
I just want to state for the record that,
So what I'm asking you right now, Mr. Ortega, is to tell me whether or not there's any other questions or evidence that you wanted to get from Mr. Bevan. That's what I'm asking you.
No.
Yeah, this judge has no chill in his bones at all. And I love the fact that he continues to tell the defendant that his legal strategy to excuse his non-compliance and to modify his bond conditions so that he doesn't have to prove that he's still not drinking are about as relevant as his IQ.
Okay. So based on that, Ms. Pearson, did you have, let me back up a little bit. Mr. Ortega, there are, I don't believe any other witnesses that are present here today, other than yourself. So did you want to testify and provide any information to the court?
I mean, is it really going to help my testimony?
Sir, I'm just asking you if you want to testify. And then let me ask you this too. Were there any other witnesses that you wanted to call today that are not present?
Yes, her name is, she's the one that manages the mobile breathalyzers. And I asked, Mr. Schultz.
Do you know her name?
Yes. Can you give me a minute though?
You know, Miss Tuttle, can you tell me who that is? Do you know who that is?
Yes.
So, Miss Brandon, what were you going to ask Miss Brandon?
Well, she told me, and I have a witness to this, and that she wrote it down, and the date that Mrs. Brandon said she called and left my cell phone on the message machine. She said, "Congratulations, you passed." And so I thought I kept the machine, but I do have a witness of somebody hearing it when I played it.
When was that?
And this was, well, in August, I believe.
Okay, and so that was the extent of what she left the message, is that you passed?
She said, "Congratulations." And she goes, "You passed, come into the office and we'll sign some papers and you're free to go." That's what,
Okay, so you took that to mean, Mr. Ortega, that you didn't have to do the mobile breath testing anymore?
well, when she said, "Congratulations, I passed," I figured I didn't have.
Is that what, did she tell you that you didn't have to do the mobile breath testing anymore? Did she tell you that on the message, sir? Did anybody from RMS tell you that you didn't have to do mobile breath testing anymore? Did you ever come into the office and ask them to clarify that message that you got? And to clarify whether or not you needed to continue with the mobile breath testing, sir?
Your Honor, respectfully,
Answer my question, sir.
she told me to bring the mobile breath test back to the office.
Did you do that?
Yes, I did.
And what happened when you brought it back?
They took it and accepted it, and that was pretty much it.
Okay. Did you want to testify today, sir?
To be honest, I'm a little bit,
I'm just asking you if you want to testify, Mr. Ortega. Do you want to testify or not? Have a seat. Ms. Pearson, is there any other information that you'd like to present today?
No, Your Honor.
Ms. Tuttle, I'd like you to come back up if you would, please. And go ahead and have a seat here, Ms. Tuttle, and I apologize. I appreciate you staying. Mr. Ortega, I'll give this back to you, sir. And Ms. Tuttle, just state your name if you would. We're going to take a quick recess. I apologize to let Mr. Ortega use the restroom.
Either he has the bladder and the intelligence of a 2-year-old, or he's drinking as much water as he can to dilute his urine just in case he has to take a piss test today, which they're eventually going to make him pee in a cup. Nevertheless, they do return and the judge has a few more questions for the original witness.
So go back on the record on Mr. Ortega's case, 24 CR 1329. And Mr. Ortega is present representing himself. I've got Ms. Pearson here on behalf of the people. And I've got Ms. Tuttle on the stand. And Ms. Tuttle, again, you're still under oath. And if you would, just state your name again.
Janine Tuttle.
Ms. Tuttle, you've been present in the courtroom. You've heard certain statements that Mr. Ortega has made. As it relates to the mobile breath testing unit, can you talk to me about what occurred with that unit, if you're aware of it?
Yeah, so, from my understanding, well, he hasn't been taking the tests. I believe he tried handing it to Miss Pearson. And then, I was like, well, you should have taken it because they cost $1,000. So if he's not, we would rather get that back. He was telling us that he admitted it into evidence for the FBI or something like that, and that's why he wasn't taking his tests. So when I found out that he tried to give it to her, I said, well, you should have taken it. And then somehow, I think she talked to Schultz, and then Schultz told him to turn it in. And then a female came to the office and returned it.
Okay, so the mobile breath unit is currently at RMS. You
Yes,
guys
it is
have
on
that.
my desk.
And he talked about Miss Brandon, or you actually had indicated it was Miss Brandon. What's her role in doing the mobile breath?
So she's an electronic home monitoring case manager. So all she does is monitors like that they're taking their tests. If they don't, then she calls them. If they have a positive, then she calls them.
Okay. And if there was a determination made that he no longer needed to be on the mobile breath unit, is that something that you would be aware of?
I would have been aware of that, yes.
And were you made aware, or did you become aware that in fact he no longer needed to do the mobile breath testing?
No, that's why we continued trying to get him to take the tests and get into compliance.
Okay. And so the mobile breath unit was returned to your office when?
I would say approximately like a month ago, maybe,
Okay,
maybe a little bit longer.
okay. All right. And then, Ms. Pearson, did you have any questions that you wanted to ask Ms. Tuttle based on the court's question?
Just one, was he, after he returned the mobile breath test unit, was he ever told that he was done doing those tests?
Not by me or anybody else that I'm aware of.
Okay, thank you.
Mr. Ortega, did you have any questions?
Yes. Why would, Mrs. Landon, is it Landon?
It's Brandon.
Hey, Brandon. Why would she say, congratulations, Mr. Ortega, you passed?
Well, she was not even in the office during the time period that you're saying you received that voicemail. She was out on medical leave.
No. She done this way before, and I have the dates wrong because I do have a witness listening to that message. So if it was in August, then it was before August. And I'm pretty sure I could find the cloud that held that message.
Okay.
And I would,
Any other questions you want to ask Ms. Tuttle?
so is she out on medical leave? Because I had Mr. Schultz subpoena her today.
She's back in the office now.
I'm pretty sure I had her on the list.
There was no subpoena for Miss Brandon. If there was, she would be here.
Okay, well, I guess that's an issue that I have with Mr. Schultz because
Again, sir, do you have any questions you want to ask Ms. Tuttle?
oh, yes. On the RMS paperwork, it says I have to be in compliance with the conditions from the court within 28 days.
And that's kind of beyond the scope of what I was asking her about. Mr. Ortega,
Well,
I'm not sure that I understand that question.
the question is, it says right here on the page, if I'm in compliance within
Well, the
28 days.
document that if that's the same document you showed me, that's handwritten by you. That's not on the document that I can see. You hand wrote that on that
I
document.
did handwrite it because when they gave me the copy, Your Honor, you can barely see it right here. So I did rewrite it the way that it's typed right here.
Do you know, in terms of the bond conditions that Mr. Ortega had, Ms. Tuttle, and again, if you can answer this question, was there anything that would relate to a 28-day time frame?
No, and can I speak on the form that he's talking about? So on those forms, those are supervision meeting sheets, and it has every single condition that could possibly be ordered. So they're usually, not all the time, but usually underlined or circled or highlighted the conditions that pertain to who they're meeting with.
Okay.
It's gonna be kind of hard to see any of the highlighted conditions when the dipshit at the podium has already licked all the tasty highlighter off the paper.
So they could be used for anybody with any type of conditions, supervisory conditions.
Yes, sir.
It's just a generic form that you kind of individualize to particular defendants.
That's correct.
Okay. Did you have any other questions, Mr. Ortega?
Yes. I have proof on my RMS forms that I was in compliance within that 28 days. So, are you knowledgeable about this?
You were never ordered to 28-day monitoring of any kind. So I'm not sure what you're speaking of.
Well, no, it just says compliance, 28-day compliance.
But none of your bond conditions state 28 days.
Okay. I'm not honestly lost because this is on my forms that you're given.
It's on
Yeah,
every
and she's
single.
already explained those forms, Mr. Ortega. So,
Your Honor,
do you have any other questions
No.
you want to ask? Okay. Did you have any questions, Ms. Pearson,
No,
you
Your
wanted to ask? Ms. Tuttle, I'll let you step down. Okay. Mr. Ortega, again, witness-wise, you talked about Ms. Brandon, that you had wanted to have her subpoenaed today, but she wasn't subpoenaed. Based on the testimony of Ms. Tuttle, I don't, respectfully, I don't know. Even if Miss Brandon came in and said that, I don't think, well, in part of me maybe wants to have her come in. Do you think she'd be available to come in, Ms. Tuttle? Yep. Would it be, could she come over? If Ms. Pearson, if you're good time-wise, could she come over in the next, 10, 15 minutes? Okay, sure. And you can, wherever you're most comfortable, if you want to step out to call. Is that your desire, Mr. Ortega? Is that you want to have, call Ms. Brandon?
yes, sir.
Okay.
My testimony of what I said, it's.
Hold on a second. Let me see if she's available.
Oh, she's available, and despite the defendant being the one who requested her to testify, it's definitely not gonna work out in his favor that she's there.
On Mr. Ortega's case 24 CR 1329. Ms. Pearson's here on behalf of the people. Mr. Ortega is present. He is representing himself today. We're involved in a hearing regarding the prosecution's motion to revoke bond. And Ms. Brandon, can I get you to come up? Ms. Brandon, I'm going to let Mr. Ortega ask you some questions, and then Ms. Pearson can ask you some questions, and I'm going to ask you some questions. That's it. Mr. Ortega?
Yes, hello, Mrs. Brandon. Have you ever left me a voicemail on my answering machine on my cell phone?
Have I left you a message? Yes.
Okay. Do you remember what those messages or message was?
They all pertain to the lack of testing and that we need to make sure that the machine was working well, or that you need to update your schedule, or just make sure that you are taking your tests.
Okay. Because on a recorded message that you left me, it said, "Congratulations, Mr. Ortega. You passed. Bring in the mobile breath unit and we'll sign some paperwork and you can be on your way." You remember saying that?
I've never left that kind of message. If someone is coming off of a non-monitor, then they come in, when they bring in their equipment, there's no documentation to sign for it.
Okay, because I do have a witness of that, of a witness listening to that exact message. And it must have been before August.
Well, again, Mr. Ortega, you're kind of testifying here. So do you have any additional questions that you want to ask Ms. Brandon?
Yes, I do. The majority of the time when I was on that mobile breath unit, was I in compliance?
No. You had spurts where you would, but then it was just refused.
Okay. Were you aware of my hand surgery that I had?
Right.
Okay. Everybody knows, is this fair to say everybody at that facility?
You know, and I think that's a little too broad. I think
Is
you
it?
can ask her what,
Okay.
what she personally might know. You can't ask her what everybody else
Okay.
knows.
Okay, thank you. Is it fair to say that you knew I was on prescribed medication the whole time I was going to RMS?
I'm not sure about the whole time, but we did discuss at one point in time that you were on medication and that you were going to bring a copy of the prescription up.
Okay. Did you see copies of my prescriptions that I was bringing in?
That's more of a case management. I did not have access to those.
Okay. Is the facility aware of the HIPAA law?
You know, and respectfully, sir,
That doesn't work.
it's not, that's not relevant.
Okay. Did I ever give you, did I ever tell you that I'm having difficulties getting back to the meetings at RMS?
Yes.
Did I ever leave you messages saying that I can't make a meeting due to the fact I can't get to the meeting?
You and I never had meetings scheduled. That would have been something again for case management. I do with the machinery. So like the electronic home monitoring and your RB machine.
Right. So you're saying that you and I have never had a meeting and I sat in front of your desk?
When we were discussing your machine, yes.
Throughout the 8 months, I never had other meetings with you that sat in front of you for any reason?
Unless you had an electronic monitor, no.
That's,
You kind
Sir,
of, we would talk.
again, you can ask questions.
Mhm.
So if you have another question you want to ask, go ahead.
so are you lying right now?
Not at all.
Like I said, calling this witness to the stand was not the flex that he thought it would be. This is why you should never represent yourself, and for that matter, you should never request the attorney who would stop you from making these mistakes be removed from your case.
Because,
Respectfully, sir.
Sorry, Your Honor.
You've asked her a question. She said no. So that's her answer.
again, do you have policies and procedures of your position?
You know, and again, I think we talked about, I don't know that that's necessarily relevant here. So you don't have to answer that question. Any other questions, sir? Wouldn't want to ask.
At any point, did you see my hand in a bandage and it was wrapped up because of I had hand surgery?
I've seen your hand and we talked about the pins in
Mhm.
your hand at one point in time when we were discussing issues going on with your monitor. Yes.
Yes. On my paperwork, it says I'm supposed to blow on that thing 5 times a day at my residence. Are you aware of that?
No matter where you are, is 5 tests a day, every 4 hours.
Every 4 hours. All the paperwork that I have, it says I'm supposed to blow on that thing at my house every 4 hours. And specifically says that on my paperwork. Are you aware of that?
That's not any paperwork that we issue.
Mrs. Brandon, are you aware that, have you read everything that the RMS saying that I did or didn't do with pertaining my case?
You know, I don't think, unless she filled out that affidavit, sir, I'm not going to have you kind of speculate or ask her questions about what other people might have put in there.
Oh, I see.
You can ask her specifically, maybe as it relates to if she ever did an affidavit or ever provided information that went into an affidavit.
With you being a witness, has Janine Tuttle ever put her notary on the paperwork that you are a witness of your statements?
You know, and honestly, sir, I don't think that really is helpful to me. So, any other questions you wanted to ask?
How often were you a witness of with Mrs. Tuttle's signature on the paperwork?
You know, and that's not relevant.
Well, may I tell you why I think it's?
I don't think it's relevant,
Okay,
so.
okay. On different, this is Brandon, on different paperwork, and I did call you to ask you this question. It says that you are a supervisor, and it also said you're an officer for the court.
You know, and again, sir, I'm not sure that that's relevant to my determination. Why do you think that's relevant?
Well, because she has several different job descriptions. I don't know
So,
what,
so what? That doesn't make a difference.
well, I want to know which one she holds.
Right. And that's, she's been called as a witness. You wanted to ask her questions about the mobile breath testing unit. She's answered those questions, sir. I don't think it's necessary to get into any other things. I don't see that those are relevant to
Okay.
what the issue is today.
Mrs. Brandon, have you ever had a faulty mobile breathalyzer that ever acted up?
You know, and again, if you want to ask a specific question about your particular unit,
Okay.
then you can ask that. But as it relates to all the units that they have at RMS, I don't think that's relevant or helpful to me.
Okay. Mrs. Brandon, have I talked to you in the past and told you that my unit is not calculating right? And I had to call an after-hours service in order for them to recalibrate the unit.
You know, I've never had the discussion.
It should be on the record. I mean, I would think.
She's answered your question,
Okay,
sir.
no other questions, Your Honor.
All right, so 2 witnesses up and 2 witnesses shitting on him on the way down. But there's still
Mr. Ortega, sir, was there any other evidence that you wanted to present today?
Yes, Your Honor. I have the original bond right here of my bond
Okay,
conditions.
why don't you show that to Ms. Pearson? And you want the court to take judicial notice of that?
Yes, if you,
So this is a document, it's a copy of the bond that was, and it's unsigned, actually. There appear to be some markings on this document. I take it you made markings on this document,
you know what, Your
Mr.
Honor?
Ortega?
I actually gave you the wrong one. I got this from the court itself yesterday.
Okay. So again, this is a copy of a PR bond that was granted to Mr. Ortega. This bond honestly has been revoked previously, but this is what's been shown to the court is a copy of what's in the court file. And it's a bond that was filed. I'm just going to pull up the case real quick here. So it was filed with the court on December 9th. It was a PR bond for Mr. Ortega. And certainly the court will take judicial notice of its file. And what's been shown to the court appears to be a copy of what is in the court file. So I'll certainly take judicial notice of that bond.
And then also, Your Honor, this is my, that must be the original because it says defendant's copy, and this is what they gave me after that copy. Is that correct? How to do things? Because I'm not sure.
You know, I'm not sure, sir. What would be relevant is what's in the court file,
Okay,
because that's what was filed with the court.
okay. And I just want to make a notice with the court that the only signature that's on that real copy, and this is my defendant copy, that my signature is on there. No judge's signatures are on that
Right.
or whatsoever. So
Well, that's true.
is there supposed to be the judge's signature?
Yeah.
Because I'm not sure.
No.
No.
Nope.
That is,
It's an appearance bond, sir. The court wouldn't normally sign an appearance bond. The court sets bond, and bond was set in your case, and there were conditions that were set in your case, and those conditions are reflected in the bond. but the judge's signature would not appear on the bond.
I, this is the last thing that I'd like to file or make present with the court that, on the, advisement with, Judge Lehman. Well, I guess that's either I'll be also, but, I do have the November 16th, I guess it would be an advisement hearing. I mean, I don't really know how this works, because nobody explained this to me. All the public defenders that were appointed to me, nobody really explained any of the proceedings. And so I did let you know that, on December 16th, and I do have a copy of the transcript here somewhere, that, I made it a point that I was gonna have hand surgery on my hand December 30th.
And Your Honor, I would object at this point. I don't understand the relevance of this considering the bond was revoked and a new bond was set on April 25th of this year. So
And I'll certainly note that objection. What are you asking, sir, that I do? Are you asking that I take judicial notice of what was discussed on the record on December 16th?
Yes, I would, Your Honor.
And so tell me why you believe that's important.
Well, I had mentioned to the court that I believe that because of the prescribed prescriptions that I was on, I wasn't, I guess, I wasn't informed and knowledgeable about the proceedings, how everything went.
Okay.
And so,
And anything else?
I have, can you give me a minute? I'll find the copy right here somewhere.
What are you looking for a copy of, sir?
Well, I have, it's the advisement of you telling me if I have an issue with any of the court proceedings to let my attorney know so he can bring it up on, to the court. So, we can make it an issue that, I was on prescribed medication. I didn't know how the proceedings were going. Nobody was explaining this stuff to me. And so,
So this would have been your first appearance in court
uh,
in
Well-
front of me.
well, yes, my first appearance in court.
And why don't you tell me, with all due respect, sir, why is that important today? Why do you think, because respectfully, the case was continued over. Counsel was appointed for you. They waived advisement. So you've had counsel that was appointed to represent you. Shortly after that, I think the public defender's office entered on, they appeared on the next date that I set, January 6th. So I'm trying to understand what your point is that you're trying to make here.
Well, I was under the influence of prescribed medication drugs.
And how does that negate your necessity to be on pretrial supervision? And more importantly, how does that play an excusatory role in why you haven't followed your pretrial conditions up to this point? It's starting to sound like you just don't want to follow these conditions so that you can keep on drinking while you're on pretrial release.
And so you didn't make any decisions, frankly, where that would have been something that the court would have necessarily been concerned about, because I advised you, and certainly I don't have the transcript in front of me. I'll certainly can review that. If you want me to review that, I can take judicial notice of it. But you haven't made, I'm not sure how you feel that impacts what I'm deciding today.
Well, the whole process of going in front of Judge Lehman on the 9th of December on a monitor, the day before I went in front of that monitor, the sheriff's department gave me a value. So when I went in front of that monitor,
Well, with all due respect, sir, you had somebody from the public defender's office that was appearing with you on that date. And then you were advised and Judge Lehman Magistrate Lehman set a bond and set bond conditions.
Well,
So I'm not following your point, Mr. Ortega.
I wasn't in the right state of mind for my constitutional rights to get waived without him making it knowledgeable to me. So,
No, with all due respect, sir, I believe that Magistrate Lehman advised you appropriately. When you appeared in front of me, I advised you, I gave you time to get an attorney or make application at the public defender's office. And then you've been represented by counsel at various times. Certainly, there's been times when you've been representing yourself. So in terms of if your argument to me today, Mr. Ortega, is that when this bond was set and the conditions were set, that you weren't in the right state of mind to understand what those conditions were, is that the argument that you're making to me? Okay. So as Ms. Pearson pointed out, you were given a bond with bond conditions. Ultimately, I had to have a hearing that related to your non-compliance with those conditions. And we had a hearing and I revoked that bond and set a new bond. And that was in May of this year. So I don't believe, sir, that anything that you've expressed to me today would invalidate the conditions that were set by Magistrate Lehman. Certainly, the court would have the ability, if a motion was filed, to address certain conditions and to modify certain conditions if the court felt that was appropriate. But nothing that you expressed to me today would be an indication to me that it's a defense in some manner to your non-compliance with the conditions of the bond.
okay, when I had Carter Vaden as my public defender, he did file a motion to modify bond and he denied that.
Right?
And he didn't explain why he wanted to modify it. Because
Well, with all due respect, sir, that was a motion that I addressed and I ruled on, and I'm not going to go back and revisit it. So is there any other arguments that you want to make to me today, Mr. Ortega?
yeah, so my argument is that none of the public defenders is going to represent me against RMS. I understand. I do understand. That's just the way it goes.
No, and with all due respect, sir, you're wrong. You're wrong. You have an attorney who can advise you and give you advice about, complying with conditions, and they can represent you at hearings. You've had attorneys represent you at hearings in this case. So that is a misstatement, sir. If there's an issue and your attorney believes it's a valid reason to bring it to the court, he would do that or can do that by filing a motion. And then the court schedules a hearing and addresses that. That's the way the process works,
Okay.
Mr. Ortega.
Well, respectfully, Your Honor, I know for a fact that the public defender, the district attorney, some of the judges, and the probation department oversees and management in a way of recovery monitoring solutions. And it says it through the legislation.
Oh, poor you. You think the entire world is against you when really it's just you against yourself. And to address your statement, no, the public defender appointed to you isn't there for financial gain. The monitoring company has no financial benefit to you following or not following your bond conditions, and the judges and district attorney are just doing their job to keep a dangerous individual from being a danger to the rest of society. Now, it is this point in the video where the judge gets tired of his excuses and turns the turntables back on the jackass.
Sir, they are contracted with the county and they provide a service to the county. They provide an assessment of when an individual's arrested, they provide an assessment of that individual and make recommendations on the bond, what bond might be appropriate. And then certainly they can monitor conditions that are set by the court. There's, in my view, nothing inappropriate about any of those things that RMS does.
Okay.
All right. The fact that you don't agree with them and that you took steps to tell them that you weren't consenting to their testing your urine samples or anything like that, it frankly is irrelevant. You don't have the ability to unilaterally change that. That's a court order. That's a condition of your bond. So until the court modifies that bond, that's your obligation to comply with it. That's one of the reasons that you got a bond, potentially a PR bond, at least initially, is with certain conditions, that you comply with those conditions. So I'm going to cut to the chase here, Mr. Ortega. Respectfully, sir, I want you to tell me whether or not you believe that you physically have an inability to comply with the conditions that are set by the court on this bond.
I believe that I do have
What is that
a
disability?
physical disability.
What's the physical disability that you have?
The physical disability is, or was, that I was on prescribed medication.
No, but you're not now, sir. You're not on any, or are you? Are you on prescribed medication now? Okay. So you tell me why today you are not able to comply with the conditions that have been set, which would be the intensive supervision and the level 3 DUI supervision.
Well,
You tell me why you can't comply with those, sir.
if we can all come to a decision.
No, sir,
I-
I'm asking you to tell me why you don't believe you can comply with those conditions. Is there a medical reason that you can't comply with those conditions?
There was a medical reason. There's
Not now, though.
Not.
Not now. So you tell me now, today, why you can't comply with those.
I'm just stating my case.
Mr. Ortega, I'm asking you a
I
question,
can go there.
and I'm asking you because you're representing yourself now. You tell me today why you cannot comply with the conditions that were set by the court, conditions of your bond. You tell me why you can't comply with those.
Because I believe that my constitutional rights were waived without my knowledge. And so that has
That is the only thing that you can come up with today, is that
That-
you believe your constitutional rights were violated because of the fact that when you were initially advised you were on prescription medication? Is that,
Well, no, that's not true, Your Honor. The sheriff's department gave me a volume that stayed in my system for a.
well,
week and-
certainly not in your system today, sir. So is that your objection? Is that you don't think that when Magistrate Lehman set the conditions of the bond back in December of last year, that you didn't understand what
I
those
did not
were?
understand. I
So
did-
that's not a reason that you can't comply with the conditions today, is it? If you think that it is, you're wrong. It is not a valid reason that you cannot comply with these conditions, Mr. Ortega.
I-
So
Your Honor-
that reason is invalid. So you tell me, is there any other reason why you don't think you can comply with the conditions of the bond?
Your Honor, respectfully, is there a reason why you're yelling at me right now?
Yeah, because you're not following me, sir. So you tell me, is there another reason why you can't comply with these conditions?
Honestly, how I feel right now is I like to ask for a recusal on you.
Your request is denied.
Well,
Mr. Ortega, I'm
I-
resolving this issue today. So I'm asking you
I
again.
would like a second
Sir,
opinion on that.
Yeah, it's my case, my call, my courtroom. You tell me if there's another reason why you can't comply with these conditions.
At this time, I can't answer that, Your
Okay,
Honor. I mean,
so here's what I'm gonna do, Mr. Ortega. You can have a seat. Have a seat at that table. Have a seat.
You're gonna put me in jail
Sit
today?
down and have a seat at the table.
I will have a seat, Your Honor. I know you're gonna put me in jail.
Sir, sit down.
I think the world would be a much better place if we just had a few more judges like this one. And if you really want the judge to throw you in jail, just keep on running your crayon muncher instead of answering his very direct questions. Now let's hear what the judge has decided to do on this case.
This matter has come before the court today for hearing on a motion to revoke bond. The court has heard testimony from numerous individuals associated with RMS, including Ms. Tuttle and Ms. Brandon. And the court's heard statements from Mr. Ortega. This bond originally was set back in December of 2024 by Magistrate Lehman. And the conditions that were set were based on the recommendations made by RMS in their bond information report. The recommendation back then was for an enhanced PR bond. Magistrate Lehman set a PR bond and then ordered certain conditions as part of that bond. He ordered intensive supervision and level 3 DUI supervision. This case has been pending for a period of time. The court had previously heard a motion to revoke bond and had revoked the PR bond and then set bond at $25,000 cash or surety with the same RMS conditions. The testimony today has established that Mr. Ortega is in violation of those conditions to the extent that Mr. Ortega contends that in some manner his mobile breath testing unit, he was advised that that particular portion of his bond was completed. The court does not find those statements to be credible based on this testimony of Ms. Tuttle as well as Ms. Brandon. The court would find by a preponderance of the evidence at a minimum, and frankly at a higher level, that he has been non-compliant with the conditions of his bond for a significant period of time. The intensive supervision has certain requirements. The level 3 DUI supervision has certain requirements. And Mr. Ortega has chosen to violate those based on his belief, I think, or belief that in some manner his rights were violated when he was initially advised that he had the ability unilaterally to prevent the testing of any samples that were provided to him as a condition of his bond. And frankly, that he doesn't agree with the requirements and has contested in some manner that RMS is not an agency that's qualified or in a position to do the testing that's been done. The court respectfully finds all of those arguments to be irrelevant. The court does believe that the bond that was set was appropriately set. The conditions were appropriately set given the nature of this charge. And the court believes that Mr. Ortega has just chosen on his own not to comply with these conditions. The court has requested of him the reasons that he is not in a position today to comply with the conditions that have been set. And certainly he has not indicated to the court that he's on any type of medication, that he's suffering from any type of disability that would prevent him from complying with those conditions. His main argument is that he believes his constitutional rights were violated when the bond was initially set. He's also expressed a concern about this court being able to hear this case. And the court does not find that any of those reasons are legitimate. And I'm making my findings, Mr. Ortega. So what the court's going to do in this case, and Ms. Tuttle is still present in the courtroom, I'm going to take this motion under advisement. I'm not going to revoke the bond today. I'm going to reserve the right to revoke the bond in the future. I'm going to require that Mr. Ortega obtain a consent from his bondsman first, that the bondsman is willing to remain on the bond given this these RMS allegations of non-compliance.
It sucks to be him, especially since a bondman can now just relieve himself of the responsibility of ensuring that he follows his bond conditions, while at the same time keeping the money that he put up for his own bond.
I'm going to order, Mr. Ortega, that you comply with the conditions that have been set. So that's intensive supervision. It's level 3 DUI supervision. So what is required is daily in-home BAs with a mobile breath testing unit, a minimum of 2 urine tests per month. Office BAs would be allowed at the discretion of the case manager, or again, that you report to RMS. I'll order that you comply with those conditions. And I'm going to set another date, Mr. Ortega, And I'm going to, in effect, sir, giving you an opportunity to get in compliance with the conditions of the bond that have been set. And Ms. Tuttle, if I can get you to come back up one more time, and I'll just have you stand at the podium and state your name.
Janine Tuttle.
Ms. Tuttle, so I'm ordering basically the same level of supervision that has always been in place for Mr. Ortega. And I'll require that he report to your office. So I want him back on the mobile breath testing unit at a time that you deem appropriate. And so he's to comply with intensive supervision as well as the level 3 DUI supervision. And you're comfortable with that?
Yes, as long as he stays in order for us to get him back on. Would you like a baseline UA done today?
Yes, I would, because he has not given a UA for a period of time. Is that right?
That's correct.
Okay.
I guarantee that the results of his piss tests are going to come back at about 80 proof.
So, Mr. Ortega, this is your opportunity. From my perspective, the arguments that you have for not complying with the bond, I've deemed to be are frankly irrelevant, and they don't excuse you not complying with the conditions of the bond. So I'm going to give you an opportunity to comply with the conditions that have been set. And then certainly if you violate those conditions, I'm going to set a hearing date or a review date, and I reserve the right to revoke your bond on this next date if you're not doing what you're supposed to do. And I'll just encourage you, Mr. Ortega, as I've encouraged you all along, to comply with the conditions. The reasons that you've stated are not, in my view, legitimate reasons for you not complying with the conditions of the bond. And in terms of the bond conditions, I just want to make sure, Ms. Tuttle, maybe so there's no confusion, I'm ordering intensive supervision, because I think that was what originally was ordered, with a level 3 DUI supervision. Clarify for me and for Mr. Ortega what that means.
So intensive supervision, he has to report once a week for either a supervision meeting or a physical check-in. The level 3 DUI supervision is the mobile breath unit, and then the day reporting, the urinalysis testing, minimal 2 times a month.
Okay. And then the baseline UA.
Right, so, yeah, so I mean, he could have 3 UAs this month.
Okay. All right. Mr. Ortega, I'm going to order that you comply with those conditions again. Let's set a date for a review. How long do you think, Ms. Tuttle, to get him hooked up?
Well, our office, we go to lunch at 12:30 to 1:30, so if he comes back in, I mean, if you want us to go over the conditions of bond
And
again.
I do.
Okay, so half an hour to an hour.
Okay. So you, and if I set this out a little bit for another review, it's not going to take very long to get him set up.
No.
Okay. So I'm going to go ahead and continue this over to December 29th at 9 o'clock. I'm just going to put it on for a review. And Mr. Ortega, I'll need you to be present. And then, Ms. Tuttle, if I asked for an updated report prior to that date indicating Mr. Ortega's compliance, is that something that you could provide or your office could provide?
Yes.
Okay.
How far else are we just gonna be,
Well, until this case gets resolved, Mr. Ortega?
I still representing myself?
Yes, you are.
Okay.
And so, again, we can have a discussion on that date about the trial, but at this point, respectfully, Mr. Ortega, if you want to try to hire an attorney to represent you, you certainly have a right to do that. I'm not appointing another attorney to represent you. So you'll have to make a decision on the date of trial that we have set. My intention is to proceed to trial and have you represent yourself.
And what date is that?
It's February. And then I'm going to give you a chance also, Mr. Ortega, if there are any additional motions that you want to file, I'll give you until the 29th to file those. And your trial is set. I've got a trial call on February 13th. And then the jury trial is currently set for February 24th.
I'm sorry, say that again, Your Honor, February.
February 13th at 1:15 is a trial call date. And then your case is set for trial on February 24th at 8:15.
The trial call, what is that?
That's an opportunity where we talk about the case and how the case is going to proceed at trial. So talk about things that are going to happen at trial.
It's February 13th.
1:15 on February 13th. And then the trial is February 24th at 8:15. And then again, December 29th at 9 o'clock. So if there are motions that you want to file that relate to the case, evidentiary motions, you'll need to have those filed by the 29th of December. And if you file any motions, I'll set that for a hearing. But I'll need you, Mr. Ortega, to be in compliance with your bond. If you're not compliant with your bond, sir, I can revoke the bond. I can set different conditions. I'm just going to encourage you, sir, to comply with the conditions of the bond that have been set.
I like to make a point if because I feel like I'm already guilty with this already.
Whoa, slow down. If you hadn't fired your public defender, then he'd probably be telling you that anything you say can and will be used against you at trial.
So
Mr. Ortega, with all due respect, hold on a second. If Ms. Pearson is willing to speak with you about this case, and if you want to try to work out an agreement with the DA, and I think at some point, frankly, there had been an offer that had been extended.
Yes, Your Honor, the offer is still on the table. It's to plead guilty to DUI as a misdemeanor with the statutory minimums. This offer's been on the table through 3 attorneys now.
Okay. So that's an offer that's on the table, Mr. Ortega. If you want to accept that offer, I'm comfortable accepting that offer.
well,
So hear me out here. So your choices are this, sir. You can certainly hire an attorney if you want to do that. I'm not going to appoint another attorney to represent you, though, based on the discussions that I had today with you and Mr. Schultz. If you want to accept the offer for in effect, a misdemeanor DUI charge, that would mean that the felony charge would be dismissed. And then you can certainly accept that, and I'd be happy to accept that deal.
Your Honor, I was not driving.
Well, and that's up to you, Mr. Ortega. You have a right to go to trial, and you have a right to present your side of the case. That's the way this system works. The fact that you say you weren't driving, if the DA agreed with that, then they could certainly dismiss the case. But that doesn't appear to be the case. So they believe that they can prove that you committed the offense that you're charged with. And the fact that you have prior DUI convictions is what makes it a felony and what makes it a more serious charge. So again, it's ultimately up to you if you want to accept an offer. Now, the other thing I will tell you is this, is that even if you feel like you're not guilty of this offense, you can certainly make a decision to accept an agreement. Even if you feel like you're not guilty, if you feel like it puts you in a better position than you would be at trial. So for example, if you think that you would run a risk at trial of being convicted of something more